Hi everyone, thanks very much for joining us. My name is Nicholas Reid from Reid Corporate, and it's my great pleasure to introduce this investor webinar with Energy Transition Minerals ASX ticker ETM. ETM is an international resource development company which owns the world-class Kvanefjeld rare earths deposit in Greenland. As global demand for critical mineral surges, ETM's Kvanefjeld project is set to play a vital role in the global green energy transition, supplying essential rare earth elements for wind turbines, electric vehicles, and other clean technologies. Because of its scale and geopolitical significance, the Kvanefjeld project has the potential to fundamentally change the global rare earth market, while also aligning with both Greenland's economic aspirations and the European Union's Critical Raw Materials Act, positioning it as a strategic asset for reducing reliance on non-EU sources of rare earths. ETM is also focused on acquiring, exploring, and developing critical minerals projects globally. We're very pleased today to have the full ETM executive team joining us on this webinar, and I'd like to quickly introduce them. Firstly, we're joined by the company's recently appointed non-executive chair, Simon Kitston, who joins us from Sydney. Simon, good to see you.
Great to be here. Thank you.
From Singapore, Daniel Mamadou, the company's managing director. Daniel, welcome.
Thank you very much. It's a pleasure to be here today, Nick.
From Perth, we've got the company's executive director, Sarah Kelly. Sarah, welcome.
Thanks, Nicholas.
And finally, joining us from Greenland, I'm not sure what time it is over there, but the company's general manager of Greenland operations, Sven Hardenberg. A great pleasure to see you, Sven, as well.
Oh, thank you. I'm happy to be here. Looking forward to it. Thank you.
Thanks, everyone. Well, we'll get straight into it. Simon, if I could start perhaps with you. You've recently joined ETM as chair. Given your vast experience in the resource sector, what attracted you to the company and what opportunities do you see for ETM moving forward?
Thanks, Nicholas. I'm attracted by the huge opportunity to unlock value from the world's most significant rare earth project. With a huge resource, in fact, over 1 billion tonnes, and an ore reserve in excess of 108 million tonnes, Kvanefjeld has scale and grade. Kvanefjeld is shovel ready, which means near-term economic benefits. These are benefits to the Greenland government. In fact, more than $22 billion worth of tax revenue over a 30-year mine life. Benefits to the local community in the form of hundreds and hundreds of well-paid local jobs. And of course, enormous upside to ETM shareholders. There is just one catch. We need to resolve the permitting situation with the Greenland government. ETM is committed to protecting its legal rights, but we're also committed to working constructively with the government and the local community to finding a commercial resolution that has the potential to unlock this project and deliver value for the government, the community, and our shareholders.
Thanks very much, Simon. Let's dive a bit deeper into the Kvanefjeld asset itself. Daniel, if I could bring you in here, perhaps if you could give us a brief overview of the project in terms of its location, scale, and perhaps a bit of the history behind it as well.
Yeah, thanks a lot, Nicholas. And Simon's gone over some of the metrics of the project, but with respect to the history, the exploration license was originally granted in 2007. And activities with respect to exploration started around 2010. There was a feasibility study that was released about 5 years later in 2015. It was then further updated in 2016. And we had an optimization process in 2019, which led to, as Simon indicated earlier, a potential mine life that goes over 30 years. So that's essentially one of the world's largest identified mineral resources of rare earth. The company closely cooperated with the various Greenlandic governments over the years with a view to developing the project. There was an environmental impact assessment that was conducted, the studies during 2015 all the way until 2019. These were eventually compiled into a document, the EIA, Environmental Impact Assessment, and that was approved by the Greenlandic government for public consultation in 2020.
Thanks, Daniel. So just to take the story forward a bit, despite adhering to Greenland's environmental guidelines on international best practice for over a decade, and despite holding an exploration license based on long-standing statutory and contractual rights, the Greenland government passed an act in December 2021, which effectively prevented the project from moving forward. Daniel, can you tell us a bit more about that and explain what exactly is the Greenland government's Act 20 and why has it halted progress at the project?
Yes, absolutely. So the Greenlandic Parliament passed Act 20, which is also called the Uranium Act, in 2021, and essentially that created a ban against the prospecting and the exploitation of uranium in ore deposits that carry grades that are above 100 parts per million in the total resource. Now, like many rare earth deposits around the world, Kvanefjeld contains a small quantity of uranium, and that mineralization is common alongside rare earth elements. And in our case, we are at about 300 parts per million. So the presence of uranium in the ore body means that the government of Greenland has stated that it would not grant an exploitation license for the Kvanefjeld project.
So Daniel, why does the company believe that it has such a strong case against the government, and why do you believe it's essential to defend the company's rights in relation to the project?
So, look, it is a fundamental principle of the Greenlandic mining law that a right to explore certain minerals entails an automatic right to exploit these minerals. The mining law is based on this key incentive, which is fundamental in order to attract investment from mining companies into Greenland. In connection with adopting this fundamental principle, the legislature recognized that no mining company can be expected to invest substantial time, resources in exploration without having an automatic and exclusive right to move into exploitation if the company finds commercially viable mineral deposits. So exploitation and exploration are two interconnected phases. And this is clearly expressed in the standard terms of the Greenlandic exploration licenses. So the government of Greenland doesn't have discretion rights with respect to whether a holder of an exploration license may transition into the exploitation phase. That discretion is already utilized when the government decides to grant an exploration license in the first place. So it is our assessment that we have the right to obtain an exploitation permit, and it is that right that we are trying to enforce. If it's proven that we're not entitled to the right, then we believe that we've been subjected to expropriation, and therefore we should be entitled to compensation. You see, Nicholas, this case is about upholding the law, the rule of law in Greenland and Denmark, and about holding Greenland to the commitment it made to ETM subsidiary, Greenland Minerals, in 2007. We're simply seeking to exercise a fundamental right under Greenlandic law to move our exploration license at Kvanefjeld into the exploitation phase.
Thanks, Daniel. Sarah, I might bring you in here. Can you explain what steps the company's taken from a legal perspective and how the case has unfolded over the past few years?
Sure. Greenland Minerals had applied for an exploitation license in 2019, and we were well advanced through the white paper consultation process with the government when the Uranium Act was passed in December 21. Having adopted the Uranium Act and indicating to Greenland Minerals that the Act would be applied to stop the Kvanefjeld project, Greenland Minerals was forced to initiate arbitration to protect its rights. This process was commenced in March 22. Litigation funding was secured for the case. The company lodged an amended exploitation license application without uranium production in December 22. In June 23, the government formally refused the original exploitation license application, which included uranium production. Our memorial of claim was filed in July 23, setting out our substantive case. In September 23, the government then refused the amended exploitation licence application with no uranium production. The governments filed their defences in January 24. The defences were focused on their objections to the jurisdiction of the tribunal over the dispute. The government sought bifurcation of the dispute, meaning that the tribunal will first determine, separately from the substantive question of the rights of Greenland Minerals to an exploitation licence, the jurisdictional objections of the governments. There was a hearing on this application in June 23, and the tribunal ordered bifurcation in October this year. The decision to pursue arbitration was based on a contractual agreement contained in the exploration licence from 2007. Arbitration was the agreed upon dispute resolution mechanism outlined in that agreement, which means that Greenland Minerals is acting fully in line with the contractual premises of the project. Under the law, if there is an arbitration agreement, one must first pursue arbitration. Separately, Greenland Minerals has sought judicial review of the government decisions to reject both exploitation licence applications, and did so by filing suit in the courts of Greenland and Denmark in May this year. This litigation is a parallel track also seeking to protect the company's rights. Greenland Minerals is simply seeking to protect its rights and is following the dispute resolution process agreed upon. Arbitration is a formal contractual step embedded in the exploration licence and reflects the company's allegiance to honouring its commitments and the relevant legal processes.
Thanks, Sarah, for stepping us through that, obviously a very complicated history there. Daniel, I suppose one of the crucial questions here is that given that ETM's focus is on rare earths, do you believe that the Kvanefjeld project can be developed and mined in a way that aligns with the objectives of Act 20?
Yes, Nicholas, absolutely. And look, under the development application that we've lodged with the Greenlandic government, we were very clear the company would only exploit rare earth elements, zinc and fluorspar. Right? The uranium would be treated as an impurity and would be safely separated and stored in a tailing storage facility. Even though we made it very clear that we will not be exploiting uranium, the Greenland government has formally refused to accept this development application on the basis that Act 20 still applies, despite the fact that we are not exploiting uranium. Now, this is somewhat confusing for us as a position because it's not consistent with some of the declarations made by the Greenland government to contribute to global efforts in the green energy transition and to support the establishment of a more diversified supply chain of critical elements. This project, Kvanefjeld, actually reduces the reliance on non-Western sources of critical materials that are essential for clean energy technologies. So, yeah, that's where we are.
Thanks, Daniel. Just a quick follow-up to that. The ongoing litigation is funded by the company's litigation partner, Burford Capital. Can you explain how that agreement works and what the broader strategy is in relation to the litigation and the arbitration process?
Yes, of course. Around June 2022, we entered into a litigation funding agreement with Woolridge Investment LLC, which is a wholly owned subsidiary of Burford Capital. And that was to fund the arbitration costs in the dispute with the government of Greenland and the government of Denmark. Now, what this funding agreement does is it underwrites the entire budgeted legal cost for the arbitration case. This funding agreement enables us to preserve our cash reserves as we seek to progress perhaps other projects in our asset portfolio. Essentially, this funding facility is a parallel line of financing. It helps us provide more certainty on our costs, and it helps maintain our liquidity while the arbitration is ongoing.
Thanks, Daniel. We'll come to other projects shortly, but just a couple of additional questions to wrap up on the legal side of things. Sarah, the arbitral tribunal recently ruled in favour of the bifurcation of the proceedings concerning the project. What does this announcement mean in practical terms, and what are the next steps in terms of litigation through the court system?
Sure. The bifurcation means that the arbitration proceedings will now be undertaken in two phases. The first will focus on the government's objections to the jurisdiction of the arbitration tribunal. The second phase will then focus on our rights to an exploitation licence, the government's liability, and the company's rights to damages. The timing of the next steps for the arbitration proceedings is yet to be determined, and the preliminary aspects of the litigation, which will provide us a clearer picture of the expected timeline, are expected to be resolved by Q2 next year.
Thanks, Sarah. And just one final one. Can you give us a sense of what the overall timeline is for the litigation, and what budget has been set for that timeframe, and what are the expected milestones that investors could look out for along the journey?
Thanks, Nicholas. The company is seeking to consolidate and streamline the actions to the extent possible and have them referred to a higher court to allow the case to move forward more efficiently and at a lower cost to parties. The overall timeline for the litigation will depend to some extent on the outcome of the procedural steps and whether the case proceeds primarily before the courts of Greenland or Denmark, and then whether the decision of the courts at first instance is appealed. An approximate estimate is that this could be a final unappealable decision in somewhere between 2.5 to 5 years from now. The timing of the various stages of litigation will not be completely within the control of the company, as it will depend to some extent on the respondents, court availability, and so on. Key milestones would be a decision on referral of the case to a higher court, the hearing and then a decision at first instance, an appeal to the Supreme Court of Denmark, and then the final decision of the Supreme Court of Denmark. We will seek to contain the costs of the proceedings within the overall budget that was contemplated at the time of entering into the litigation funding agreement, and we will seek to avoid the scenario of both the arbitration and litigation being actively pursued simultaneously, and may seek to stay the action in one of the forums to avoid duplication of costs for all parties.
Fantastic, thanks, Sarah. So, look, enough on the legal side of things. Let's bring Sven in over in Greenland. Welcome, Sven. The company is pursuing a wide-ranging engagement strategy in Greenland and Denmark with regard to Kvanefjeld, including your own recent appointment to the board of Greenland Minerals. Can you firstly give us a bit of a background on yourself?
Well, thank you, Nicholas. I should try to do that. Well, I'm an Inuk, which means that I'm a native Greenlander, born and raised in Greenland. I took my high school degree in Denmark and also my university degree as well. I have had a lot of experience within different areas in Greenland on sea level positions. The last one was being the permanent secretary at the Premier's office for the government of Greenland. I also have a long-standing career within the utilities sector, where I was the CEO of the National Energy Company for many years. So I spearheaded the whole green transition in Greenland, commissioning a lot of hydropower plants and district heating systems and so forth. My original background is within commercial airline. So I've been on the sea level in the commercial airline as well. So all my life I've been working with infrastructure.
Sven, can you give us your perspective on the role of engagement and constructive negotiation versus litigation?
Yes, I think that it's the right path, and we have been discussing this within the management, and I believe in the project, and I see a huge benefit for our country in securing that we have the ability to actually start producing from the project. And that means that we need to engage more actively with the community of Narsaq and Greenland in general to secure that people are well informed about facts surrounding the project, because we experienced a lot of miscommunications and misinformation surrounding the project up to the election in 2020, and that actually affected people's perception of the project very much in a negative direction.
Thanks, Sven. And the winds are also changing in relation to the adoption of uranium and nuclear energy globally, and there's a big push in the EU to support the development of critical minerals. How does that changing landscape potentially benefit ETM and the Kvanefjeld project?
Well, looking at the overall perspective, it had a huge impact in regards to a growing interest towards the project from the international side. But I would like to look at the opposite, turning the period around and looking at how the perception in NASA has changed towards the project. Because I've been frequenting NASA since my engagement in the company, and at first, I was so curious in understanding where people are right now in regards to the perception towards the project, and it seems that has shifted a lot since the election in 2020, and after the decision about the Act 20 in 2021. And it seems like we are in a situation where it's 50-50, both pro and against the project. And that's without the company actually doing anything actively in trying to mitigate information and the situation in an overall perspective.
Thanks, Sven. We'll try and sort of wrap up on this discussion around the in-country activities, and maybe I'll just ask Sarah and yourself just for summarise for shareholders a couple of key factors that you believe support ETM's position in relation to the project, and why shareholders should be optimistic that a positive outcome is achievable. Sarah, would you like to go first?
Thanks, Nicholas. My answer would be the strong legal case. The exploration licence clearly grants Greenland Minerals the right to an exploitation licence, and the opposite view has only surfaced with the political change in 2021. This aligns with Section 29.2 of the Mineral Resources Act, which states that GMUS had a right to an exploitation licence upon meeting the necessary conditions. This is in addition to the economic benefits generally accruing to both Greenland and Denmark arising from the development of Kvanefjeld. Thanks.
Thanks, Sarah. Sven, last words from you.
Well, I would say there's a huge economical benefit in regards to allowing the project to go forward, not only for NASA, but also Greenland in general. And my belief is, at least with the dialogues I have had on an ongoing basis, also on the political level in Greenland, is that the winds are changing to the positive towards the project. And that's not only in regards to the increasing international interest towards the project, but it seems like people need it, the world needs it, and I think there's an opportunity in securing that people are well informed in a factful way to secure that they have an ability and a wish to revisit the decision that was made in Parliament in 2021.
Thanks, Sven. I'll go now back to Daniel and Simon just to wrap things up for us, and let's talk about the ETM investment proposition moving forward. Daniel, firstly, the company's got a strong cash balance and you've been building a diversified portfolio of critical minerals assets, including recently exploration projects in Spain and Canada. Can you tell us what the rationale is behind your diversification strategy and the status of your current projects?
Yes, Nicholas, of course. I mean, look, while we await the outcome of the legal process at Kvanefjeld, we have to acknowledge the importance of considering alternative strategies to grow. And after taking on board feedback from shareholders and investors, we decided to look at additional exploration assets. In Canada and in Spain, both jurisdictions have a strong tradition of mining that's supported by stable and attractive codes. We added an asset in Canada recently, which is in the James Bay region of Quebec, which is highly prospective. We conducted a Summerfield reconnaissance program on our licenses. The results revealed compelling prospectivity for lithium, cesium, and tantalum pegmatites. We also recently completed the second round of drilling in the Villas Rubias lithium project in Spain, with lithium tin and tantalum mineralization intersected in several drill holes. So these assets, although early stage, offer long-term potential. And company's next step will be to take into consideration market conditions with a view to leveraging our resources in the best way to create long-term value for our shareholders. We're constantly scanning for new opportunities that can be accretive for our shareholders, and we look at the entire globe, including in Greenland.
Thanks, Daniel. Simon, you've been in this game a long time. I'm interested to get your views on this. You've got a great track record building, successful companies in the resources space. What sort of opportunities or projects are you looking for, and what criteria do you generally apply when you look at potential acquisitions?
Well, as you've just heard, our clear focus, firstly, is to resolve the situation in Greenland. That's the number one mission of the company. That said, the company does have a very strong technical team, and we do have a focus very much on energy transition minerals, which specifically I mean rare earths and copper. So when we look at new projects, I guess we're looking at sort of tier one jurisdictions, very large resources, high grades, and projects that we can meaningfully advance.
Thanks very much, Simon. Daniel, you've brought some new people into the company recently at board and leadership level. What skills and experience does the team have, and how are they relevant to ETM's strategic focus?
Well, look, they're very relevant, and we're very fortunate to have a board and a management team with the skills and knowledge base that spans across a number of different areas. Our newly appointed chairman, Simon Kidston, has a background in investment banking. He's got a very strong track record of building successful companies and building successful teams focused on mining and renewable energy. We've got Sarah, who's an accomplished lawyer who's been supporting our legal efforts and assisted in streamlining our processes with that respect. We've got Sven, who's leading our operations on the ground and also focusing on helping us resolve the current conflict, right? Focused on approach on community relations. So I think we've got an excellent team. The company couldn't have a better group of people to bring this project forward, work with the authorities and work with the communities on the ground and move forward.
Well said. Thanks, Daniel. Simon, I'm going to ask you to have the last word here. Can you give us your sort of helicopter view of the outlook for ETM and what investors should look for in the coming months, and why you think it's a great investment opportunity?
Yeah, look, firstly, Nicholas, I see enormous upside, huge opportunity in resolving the situation in Greenland. I'm talking multiples of our current share price once the situation's resolved. So that's going to be really exciting, and I hope there'll be some positive news on that front during the course of the coming period. Secondly, the business is well funded to execute on our strategy. We've got more than 13 million Australian dollars in cash that we can utilise to advance our projects. We're having good progress with our projects in Spain and Canada, and I believe our potential to generate discoveries, not just from those projects, but other projects within our network, have the potential to materially add positive momentum to our share price as we move into 2025.
Fantastic, Simon. That's a great wrap up. And I think we've covered all of the issues that we'd set out to cover in this webinar. So I'd just like to conclude by thanking everyone for joining, to Simon over in Sydney, to Daniel, to Sarah and to Sven. Thank you very much, Sven. I know it's late at night for you over there. This is going to be the first of many webinars that you'll hear from this company in the months ahead. So we look forward to bringing you lots more news from the senior management team as the story unfolds, and look out for regular updates to the company's social channels and its website. Thank you very much for joining us for this investor webinar, December 2024, with Energy Transition Minerals. Thank you.
Thank you.
Thanks, Nicholas.
Thanks very much.